Good afternoon, everybody. You'll come to order. We'll go ahead and start the meeting. I'm going to recognize Senator Watson to present a bill to us.
Thank you, Mr. Chairman. Members of the committee, I do bring before you Senate Bill 144. This is a labeling bill, and when we're talking about crop protection tools and plant protection products, the label is the law. And so what we're doing in this bill is we're just clarifying that the manufacturer cannot be held liable for failing to warn consumers of risk above those required by the United States Environmental Protection Agency. They are the rulemaking organization that decides what goes on the label. And if a manufacturer asks to put something on the label and EPA says they cannot put it on the label, then they cannot put it on the label and they will be in trouble and they will not be able to put the product on the marketplace. So we're just clearing the failure to warn policy here, and that's what the bill does, Mr. Chairman. I'll be glad to take any questions.
Okay, I think we have a couple of questions. Representative Evans, you have a question?
Thank you, Mr. Chairman. To the author, I had heard from some folks at the University of Georgia, and I think others who are proponents of the bill, that this is really about ease of regulation and only wanting to report to one agency, the EPA, and not also having to report to EPD and any other regulatory agency. But now I'm hearing this is really about cutting off consumer claims for failure to warn. So which is it, or is it both?
State that question again.
Is this about ease of regulation and only having to report to one agency, or is this about civil immunity, or both?
It's about failure to warn of the product that they're manufacturing, that the EPA has to approve it. If they do not approve it, then they won't let them put it on the label even if they want to. So it's, I guess, a failure to warn of whatever that consequence or risk may be. But it's just saying if they want to put it on there, they can't because the EPA would not let them. The EPA has over 500 scientists. They takes up to 13 years to approve a label. It's not something that they take lightly. And so they test this, and even once the label is put on the marketplace, they don't quit testing, and they continue to testing. So if something is found later on, then they're able to address that. It does not lessen any restrictions. It does not provide any immunity. It just says in a failure to warn that they're not required to do that unless the EPA says that they can or can't.
Oftentimes industries, oftentimes industries research and development offices are ahead of EPA and EPD and others. It's just sort of the reality that happened with cigarettes. It's happened with a number of things where companies find out about harms and they may report them to the government, but the government sometimes takes a while to act on them. I've even had proponents of this bill acknowledge that sometimes that could take 6 months, it could take a year. So do you not have any concern that we may have an actor, whether it's whatever maker of a pesticide, they've found out a concern, they've reported it to the EPA like they're supposed to, but the EPA doesn't act upon that or do anything for 6 months to a year, but yet we've got an industry player that knows from their own research that something is harmful, and they continue to be able to sell it to consumers without giving that equal knowledge to them. And this bill cuts off the consumer's ability to do anything about it if they get hurt. Does that not concern you at all?
Well, I don't think it would protect them from that, and they would be held liable for that. Because
How?
Then they've misrepresented or misinformed the public, and they've misrepresented their product, so they're liable for that. I mean, that's the case with current law today. That could happen today in the current environment that we're in.
I agree.
So that doesn't protect them from that issue today.
Senator, I agree with you today it doesn't, but this bill, whether you mean for it to or not, says that as long as they've followed the regulation to report it to EPA, and then they say, we told them, we don't have to tell anybody else. If somebody gets hurt in the interim before EPA acts on that warning, you have cut off their claim, and that's very concerning to me. And perhaps you didn't mean for it to, and I've tried to have amendment language added when there was a bill over here. I had it shared with the committee yesterday. I've shared it with lobbyists in the hall who are proponents of this bill. I don't think it interferes with your purpose. If your purpose is really to ease regulations and make sure that we're having one reporting mechanism, but without that amendment, it will cut off the claim that I just described to you.
Well, I appreciate your concern on that, but I don't think it will because, again, they're doing the research. It doesn't. The state can immediately jump in. Normally, how this would go down is they would remove the product immediately from the shelf, and in this situation, some products have already been removed from the shelf just because of some of this, and so they would be held liable for that, even because they didn't. There was not a failure to warn in that situation.
Okay, we have another question, Whip Park.
Thank you, Mr. Chairman. I certainly appreciate Representative Evans' line of questioning and would otherwise agree that I think this legislation is essentially going to be weakening consumer protections, especially with respect to our agriculture industry and all of the food products. If we are lowering the standard, which my understanding of this legislation would do, again, I think to reiterate a question, but is that going to potentially mean that we may see pesticides or more harmful chemicals on food products if this legislation is passed?
No, again, it's a failure to warn. They're not, if they misrepresent or if they lie or they don't tell the truth, they're held liable for that. But this is just failure to warn. If they want to put something, if they think, if a study suggests, that's not based on science. That's not proven research. So even if they want to, or if they think that it may do something, they can't do that because the EPA will not allow them to do that.
So, Senator, on line 38, we're saying that the EPA label is a sufficient warning label. If you use the EPA label, right, that's sufficient for an action commenced under state law. Right, the FIFRA statute that this legislation also mentions has a reporting requirement for companies if that label is incorrect, which implies that there's an understanding that these EPA labels may not always get it right. Certainly in the history of our country with cigarettes, right, companies hid information, petroleum companies hid information with respect to the effects of a more volatile climate. Would this not also incentivize companies to hide information if they can simply trust and remove any sort of liability by relying on this EPA label?
No, because if they hide anything at any point in time, then they're going to be held liable for that, and there will be consequences of that. So it does not protect them from hiding any information.
Thank you.
Okay, I want to remind the members, this is the Rules Committee. This is not a regular committee of the House, but we've got some more questions, so we're going to try to honor some of the leader illustration. If I can get it turned, there you go.
Thank you, Mr. Chairman. And Senator, it's my reading of this, beginning that with respect to the questions that were asked previously, that if a determination is made by the EPA that a manufacturer knowingly withheld, concealed, misrepresented, destroyed material information regarding human health risks, that the earlier part of the bill would not apply. So any concern that the manufacturer may have this information, be aware of this information, that's specifically excluded from the legislation that you're presenting here today. Is my understanding?
That's correct.
Correct. Thank you.
Thank you, Mr. Chairman. I just want to make sure I'm understanding, Mr. Senator. If you're saying the companies are not allowed to hide the truth or mislead, and I understand that part, but how do they tell the truth if they don't warn? I mean, it's one thing for someone to ask you and then you tell the truth because you've been asked, but I guess doesn't this sort of prohibit or discourage warning people by giving this sort of not immunity but certain protections?
Well, first of all, they're going to do research themselves as the owner of or manufacturer of the product. They're not going to. They know the consequences. They're not going to put anything on the marketplace that can cause harm. Number two, EPA is also going to be testing it with their 500 scientists and researchers, and they're going to do research on that. So, I mean, and it may take 13 years for them to verify that the product is safe and okay to put on the shelf for people to use. So, again, if they fail to warn about something, If the science is not there to back it up, then they should not be held liable for that. There has to be science and research to prove that there's something that causes that problem. And if they don't have the research or science to back it up, then it's just hearsay.
When you say they, are you talking about the pesticide company or the EPA?
Talking about the consumer or whoever's concerned about the issue that they have.
Okay, Whip Burchett.
Thank you, Mr. Chairman. Thank you, Senator Watson, for bringing the bill. Is there anywhere in here that it says you cannot bring a claim for wrongful death?
No, sir.
Is there anywhere in this bill that allows or disallows the ability to bring a personal injury claim?
No, sir.
All right. In the event that I think our colleagues are mentioning that there is a determination by the EPA that the manufacturer was in bad faith hiding something that would hurt somebody, would they be covered under this bill?
No.
Thank you, Thank you, Senator.
Okay. Chairman Martin.
Senator, and the leader covered my question on line 42, the carve out for knowingly will withhold information. But let me see if I can provide a scenario, and you tell me if it would apply. If there's a product out there and the EPA is, the EPA has approved the label and everything's going fine. If later on at some point they found out that product caused something and nobody knew about it, you say that happened in 2020, and then in 2025, that product caused something that nobody knew about, and it injured somebody, they would still be able to bring a suit for that injury or, heaven forbid, that fatality or any damages, right? But they wouldn't be able to bring a suit for failure to warn because they didn't knowingly conceal or misrepresent.
Correct.
So the difference there is this isn't not true. This does not keep the company, does not reward the company for being dishonest with the public, but instead doesn't penalize them for not being able to look into the future.
Correct.
Thank you.
Yep.
Okay. That exhausts all the questions I see here. President Evans, I have a proposed amendment, I think, that I got when we walked in, and I think that's yours. And it hasn't been printed because we just got it. And normally what we'd like to do is get these at least 24 hours before so we can have a chance to get them printed and get it to it. But out of an abundance of caution, if you want to explain it, if you can do it shortly, we'll hear from you on that, okay?
Yes, thank you, Mr. Chairman. And not knowing that we were going to meet today, I didn't have any ability. I didn't foresee that I would need to get this, and this bill just passed out of its committee of purview yesterday morning at 8 a.m.
Okay.
I have been working with at least the author in the House and some folks in the hall with the amendment, so I do apologize for not having it here. But it's one page. I think it could be printed pretty quickly. But it just simply states that this will be a regulatory. The amendment just makes clear that it doesn't take out the common law negligent failure to warn claim that consumers may have, recognizing that this bill requires the steps for a company to make sure they're doing their regulatory compliance and reporting to the EPA. But if they know something and they've told the EPA but they haven't told their consumers, I don't think it's right that we cut off the consumer's ability to hold the industry accountable for not sharing that information with them, because the EPA could sit on it for 6 months, for a year, for 2 years. We just don't know, and that's true with any federal administration, Democrat or Republican. They are slow. Industry is faster, and if industry is going to continue to sell their product, they should have a duty to inform consumers the same as they have the duty to inform the government, and that's all the amendment does. It would not step on any regulatory aim that we're seeking here. And I'm simply asking, Mr. Chairman and members of the committee, that this amendment be able to be considered on the floor. I'm not asking this rules. I mean, I'd love it if the committee wants to pass it and amend the bill in here, but I'm simply asking that the members have a chance to exercise their right as members of legislators to make amendments to a bill on the floor and complying with the way you have to do that as a modified structure bill. Appreciate the consideration.
Okay, well, it's offered here in rules, so we're going to vote on it right here in rules right now. Those in favor of adopting the amendment say aye. Aye. Those opposed, no. No. The noes have it. It's not adopted. Okay, now, on Senate Bill 144, as presented without the amendment, do I have a motion on that be added to a supplemental calendar that we'll do for today when we go back in? Have a move and a second. Any opposition? There is an objection. All those for putting it on supplemental calendar today say aye. Aye. Any opposed? They are opposed. It's on. Thank you.
Mr. Chairman, in compliance with House rules, we filed a minority report on House Bill 144. Could you clarify to ensure that that will be recognized? Thank you.
Thank you, Mr. Chair.